Okay, so it is 1 o'clock. We'll start. Good afternoon, everyone. Welcome to this Francis Taylor Building Public Law webinar. The topic for this webinar is policy-related litigation. For those who don't know me, my name is Richard Honey. I'm a barrister at Francis Taylor Building and chair the Public Law Practice Group there, and indeed this webinar today. I'm very pleased to see that we've got so many people not only booked, but logged in for the webinar today. Thank you very much for joining us. You're probably all very familiar with Zoom webinars these days. We're going to try and keep it simple in terms of the technology. We'll take questions via the Q&A function on the system. You should be able to access that by clicking on the icon at the bottom of the screen. The Q&A icon will appear when you hover over the bottom of the screen with your cursor. Feel free to type in questions or comments as we go. We'll answer as many of them as we can in a block at the end after the 3 talks, or at least as many as we've got time for. We're going to stop at around 2 o'clock, even if we've not got through all the questions, but feel free to email me afterwards with any burning questions that remain outstanding. We'll try to make sure they're answered directly. All being well, we're going to be able to share our screens to show PowerPoint slides during the presentations this afternoon, but we've also got copies that can be emailed out to you afterwards. And as you may have noticed, we're recording this webinar and it may well be published on the FTB YouTube channel afterwards. So the webinar is intended to give an overview on this topic of policy-related litigation and an update on recent cases concerned with policy in all areas of public sector decision-making. So we're going to be covering the application of policy in decision-making, legal challenges to policy and guidance, including arguments about whether there are duties to follow policy when it comes to decision making, and then a number of examples of cases in policy related litigation as well. And as you'll see from the presentations as we come to make them, there's been quite a lot of litigation on these topics in the last couple of years across a wide range of public law topics. We've got 3 speakers from Francis Taylor Building today. I'll introduce each of them as they come to speak, to give them time, not least, to share their slides on the screen. Please do type questions into the Q&A function as we go, as I say. So I'm going to start now by introducing our first speaker, who is Michael Rhimes. Michael was called in 2019 and is building an interesting High Court practice. He's got experience of judicial reviews, for example, in the fields of planning, adverts, licensing, and town and village greens. Indeed, I led Michael in a pro bono town and village green judicial review, where Michael argued one of those points orally and did very well, if I may say so. So, Michael, I'm going to hand over to you, please, for your presentation.
Thank you very much for that introduction. I'm going to be addressing the nuts and bolts of policy and policy challenges, and I'd like to address 3 topics. The first is some general context to policy. The second is what can be challenged, and the third is what makes a policy unlawful. So before we begin, I'd like to present the overall picture. The rise of the administrative state is well known. There's been a growth of regulatory agencies governing specific industries and aspects of public life. To give but 2 examples, the Financial Conduct Authority or the Health and Safety Executive. And typically these agencies are afforded a broad discretion as to what to investigate, how to investigate it, and what measures to take in response to any wrongs. And so this increase in discretion leads to a tension between 2 important principles, as Mr. Justice Sedley, as he then was in Ex parte Hamblin, recognized. On the one hand, it is important to have flexibility so that these decision makers can tailor their decision making to the particular facts of the case. But on the other hand, it's important to have certainty so that the exercise of powers can be predictable. Policy can fit both bills because it can act as a general guide as to how broad discretions may be exercised, but it can also provide the necessary flexibility. It's interesting to note that this has not always been appreciated. There may have been a traditional wariness of policy, which is exemplified by the mid-19th century case of Tinkler, where Lord Justice Tucker held that these defendants, who were local authorities, have very extensive statutory powers. And he struck down the decision in question because it is their bounden duty to keep strictly within those powers and not to be guided by any fancied view of the spirit of the act which confers them. It's fair to say that the Court of Appeal in that case does not seem to have been enamored with policy. And we might now today take a different view. We might say it's legitimate for the local authority to guide its broad discretion by reference to an overall policy framework. This is going to be addressed in greater detail by my colleague, Kate, after me. But it's fair to say that the courts now recognise the value of policy because it increases certainty, as Lord Walker and Lord Hope both commented on in Alvey. So now we have reached the position where, in fact, policy may be required by statute. Two simple examples illustrate this. The first that I've given is that there's a broad discretionary power to reduce council tax payments to such an extent as the billing authority thinks fit. But Parliament has provided that billing authorities must adopt a scheme to guide that discretion, which makes sense given that you're going to have many decisions in a similar area, and it's important to have a framework as to how those decisions are going to be taken. Policy can also assist decision makers in a new area of law. So the Home Office is under a duty to issue guidance to the police for the new powers that were introduced in 2019 to prevent stalking. The final point to note is that the rule of law, or particular human rights under the 1998 Act, may require the adoption of a sufficiently clear policy. To give an example of that, in Purdy, it was a breach of Article 8 for the Director of Public Prosecutions to fail to specify the circumstances in which they would prosecute an individual for assisting the suicide of an incapacitated family member. So it's fair to say that policy is now recognised as an important tool in administrative life. So I'll now move on to the second topic, which is the targets of judicial review. It's important to bear in mind that not all policies will be a compendious written statement, and there's quite a lot that can be challenged. So the first example that I've given there is of a one-off letter sent to doctors, which dealt with the interpretation of the 24 weeks rule in the context of termination of pregnancies. And that was held to be something that could be the subject of judicial review, as in the first example that I've given there. Indeed, the policies do not have to necessarily be written down. So in 2 and 3, I've given 2 examples of a practice, which wasn't codified, but the practice as to the magistrates listing cases. And indeed, the seminal case on judicial review from the 1980s, the GCHQ case, that was an oral instruction to GCHQ, and that could be judicially reviewed. There's also administrative practices that can be reviewed, such as a complex application form. So it's important to bear in mind the breadth of what can be challenged. In addition, it is possible to review the failure to publish a policy. McMahon held that if a public body has a policy to guide its decisions, lawful decision-making requires that the policy should be public. And I've given a recent example of that, which is K, where the court held it was unlawful for the Department of Work and Pensions not to publish an internal policy on when to waive overpayments of universal credit. The internal policy was an important statement on how it would exercise its discretion to claw back benefits, and it should have been published. Still sticking with what can be challenged, in my opinion, it's helpful to consider the challenges under 3 general headings. The first heading would be fettering of discretion, and that if essentially is that a decision maker has slavishly followed policy. They've not considered whether to depart from the policy, and they've effectively applied the policy by rote without considering the facts of the case. Now, it's important to note that, as was held in West Berkshire, and this is also going to be relevant for the cases that my colleague Jonathan discusses, a policy does not need to state in terms that it can be departed from. So the mere fact that a decision maker has followed a policy that doesn't say it can be departed from, that doesn't mean that the decision maker will have fettered their discretion. However, it is possible to establish a fettering of discretion, as occurred in the recent case of Maher, where the first-tier tribunal refused to give a gist of reasons for releasing the person who killed the claimant's son. This was held to be unlawful because it applied a blanket policy of not providing reasons. That's the first category. The second category is the failure to apply policy, which is in some respects the reverse of the first ground. There may be many reasons why a decision maker didn't follow policy. It may be because they misunderstood the policy, which will give rise to a question of law as to what the policy meant. It may be that they didn't apply the policy at all, or it may be that they departed from it without giving good reasons. And again, that latter point, the departure without good reasons, my colleague Kate will be speaking about shortly. The final category is a challenge to the policy itself rather than its application. That is the third topic, which I will now turn to. It's important at the outset to recognize that in theory, a policy could be challenged as irrational or on the grounds that it failed to take into account a material consideration. There's a recent example of that, Gardner, which was a challenge to the readmission of hospital patients to care homes in the COVID pandemic. And the court found that there had been, in March 2020, a growing appreciation of asymptomatic transmission. And this required a change in policy regarding the readmission. The admissions guidance the court held was irrational in failing to take account of and assessing that known risk. And so in that case, the policy on admission was unlawful. However, it is fair to say that generally bodies will have a significant margin in how they exercise their generally broad discretions. And so it will be difficult to argue that in the abstract, a general framework for decision-making is irrational, but it's nonetheless worth bearing in mind that that is a challenge that could be made. What is likely to be more relevant is whether the policy itself is unlawful, for example, because it will result or indeed may result in decisions that are contrary to the law. This was addressed by the Supreme Court in A, and a sister case, BF, decided by the same constitution. Jonathan will be discussing BF, and I will be dealing with A. At issue was the child sex offender disclosure scheme. The divisional court in 2012 held that the scheme was unlawful because it had no meaningful provision for consultation with the subject. The subject was entitled under Article 8 to make submissions as to whether his convictions or her convictions should be disclosed. This was then updated, and the claimant challenged the updated guidance. And the ground of challenge was that there was a significant risk of violation of Article 8 because the policy was not sufficiently precise. The key takeaway from the Supreme Court's decision in that case is that the previous authority of Gillick, a House of Lords case, sets out the test to be applied when considering whether a policy is or is not lawful. In Gillick, guidance was given to doctors about giving contraceptions to persons under the age of 16 without informing their guardians. This was controversial because a person under the age of 16 can't consent to sexual relations. The guidance recognized that there were exceptional cases where a doctor could give contraception without informing the guardian. And critically, it left those cases to be determined by clinical judgment. The House of Lords held by majority that it was lawful. And A stresses that it is not necessary for a policy to read like a textbook or a judgment. And so in that case, the policy was still lawful, even though it left a significant amount of judgment to an individual doctor as to whether to give the contraception or not. So the key takeaway is that it is essentially, when a body adopts a policy, that body may decide on the extent of detail to be given in the policy. And the Supreme Court gave two reasons for this. The first is that there's a risk to public authorities, And it made little sense to disincentivize the adoption of a policy by requiring, in all cases, the adoption of what is in effect a comprehensive textbook. That would be contrary to good administration, because it would disincentivize the adoption of policy. There was also a risk to the courts, because they would effectively, whenever a policy is challenged, be required to give an elaborate statement of the law to deal with hypothetical cases which might arise within the scope of a policy. So that deals with the first aspect, which is how much detail needs to be given in a policy. The court also discussed the basis for intervention, namely when a policy will actually be unlawful. The key point is that the basis for intervention is set out in Gillick. A policy will be unlawful if and only if it has a positive encouragement to break the law. The policy must sanction, in other words, positively approve a course of conduct that is contrary to the law. The mere fact that a policy might lead to a breach of the law is not enough. Policy is not designed to prevent all illegality. It's designed to act as a framework to guide decision-making. So on the facts, there was no breach of that principle. The scheme would not inevitably operate incompatibly with the appellant's rights. It said that the police should consider whether to seek representations from the convict. That was in accordance with, and in no way contradicted, the police's legal obligations under the common law and under Article 8 of the European Convention on Human Rights. And the fact that it did not spell out in fine detail how decision makers should assess whether to seek representations in a particular case didn't make it unlawful. It was essentially up to the decision, to the issue of the policy to decide how much detail to go into. The Supreme Court at paragraph 46 provides a very helpful overview of the three types of cases where a policy would be unlawful. If there is an incorrect statement of law which would induce a breach of legal duty, then it would be unlawful. The second, where there is a duty to promulgate policy, but it misstates the legal position, that will also be unlawful. And finally, when there is no duty to promulgate, but presents a misleading picture of the position, it will also be unlawful. So, for example, in Letts, there was a policy on when legal aid for an inquest could be required under Article 2, but it omitted a significant category of cases where legal aid would be required. So it presented a misleading picture of the legal position and was accordingly unlawful. Dealing finally with some practical points, I think there are three takeaways from the Supreme Court's decision. The first is, in order to determine whether a policy is lawful, one needs to compare first, what does the law require? And second, what does the policy say a person should do? If they are inconsistent, the policy is unlawful. But critically, it's not a question of statistical probability. It's not a question of trying to decide whether the policy would lead to an unlawful decision, and if so, what are the chances of that? Rather, you compare what the law requires and what the policy requires. That's the first point. The second point is that there's no duty to go into full detail about how discretion should be exercised in each case. It's perfectly legitimate to identify broad categories of a case which may require more detailed consideration. So in Letts, the policy could have just said, in these are the kinds of cases where you need to consider whether legal aid would be required, but it didn't need to provide an authoritative textbook on every single permutation where legal aid might be required. And the final point that I will make is just in relation to the difference between unlawful treatment and unlawful policy. What we've discussed is whether the policy itself is unlawful. It's entirely possible that a policy would be lawful, but an individual case that applies that policy results in illegality. And of course, the proper course in that case would be to challenge the particular decision and not the policy as a whole. That concludes my presentation. Thank you very much for your attention.
Excellent. Thank you very much indeed, Michael. One of my favourite cases in that field is one that decided that even after dinner speeches given by ministers might amount to government policy in the right circumstances. Just a reminder for those who are attending, if you have questions or comments, please use the Q&A function to ask them. Our next speaker then is Kate Olley. Kate was called in 1999 and is a very experienced public law practitioner. She often appears in the High Court and the Court of Appeal, especially on planning related judicial reviews, and has been sole counsel in the Supreme Court. She served for many years on the Attorney General's panel of counsel and acts for claimants and defendants in a wide range of public law fields, including not just planning and environmental law, but also areas such as mental health, prisons, education, immigration, social security, community care, and all kinds of local government law. I have been against Kate, so I can vouch for the quality of her advocacy as well. So Kate, I'll hand over to you.
Thank you, Richard. I hope everyone can hear me, and good afternoon to everyone. I'm going to be looking at the duty to follow policy. And I thought we'd have some general points about policy challenges. I think it's really fair to say that now there is no power that you could say is inherently unreviewable, whether that's statutory, common law, or matter of the prerogative. Clearly, the judiciary does have a significant reserve, and that's really due to its constitutional status. It's really founded in the concept of the separation of powers, social and economic policy being for the legislature and the executive, and the court is wary of being drawn into essentially weighing the utilitarian calculations that those branches of government conduct. So some decisions aren't really justiciable or amenable. For example, if the decision is a matter of preference rather than applying objective criteria, and the court, of course, recognises that there are some examples in which it simply lacks the expertise to weigh in, where specialist knowledge is required, or where it's the result of a careful risk assessment, particularly in national security cases. Although, of course, there have been many challenges in the field of national security nonetheless. Also, where we've got what we call a polycentric decision, the court will be particularly cautious. So, for example, what we call allocative decisions. You've got scarce resources to allocate, and you can be in a situation where competing interests intersect, and if you sort of pull the thread somewhere, then the tapestry is going to pucker in another area. And sort of classic learning on that by L. Fuller was to compare it to a spider's web, sort of pulling one part of the web and there being an adverse impact on the other part. However, if there are groups whose interests weren't represented at the stage that the policy was developed or the decision was made, then the court might be more inclined to allow some sort of measure of challenge. And all this feels very comfortable to public lawyers. It dovetails with or reflects there's obviously general reluctance to interfere with the merits of a decision. However, despite this reserve, the court is, of course, able to and is obliged to require decisions to be within the scope of the legal power or duty in question, and to ensure that procedural fairness is observed. So it will scrutinise the quality of the reasoning given. Decisions have got to be reasoned, and assertions have got to be justified. So that's sort of a framework for ourselves, and I'll move on now to look at a few example decisions in this area. So the first is Mandalia. To recap that one, in the Supreme Court, it was about instructions given to caseworkers in the Home Office who were processing applications under the points-based system. The sort of 5 tiers within that system, and the instructions were to do with evidential flexibility. Essentially, if there was some uncertainty, then the benefit of the doubt should be given to the applicant. As it happened, the presenting officer didn't draw the tribunal judge's attention to that guidance, and as we'll see, the applicant himself wasn't relying on it initially. So Lord Wilson said, as a matter of overview, the management of this type of immigration, in principle, highly valuable for the UK, and that the applicant was a student in this case, is a profound social challenge of which the complexities are beyond the understanding of the courts. So that's a reference to the specialist expertise point. Carrying on, and by not exercising its right to disapprove Part 6A of the rules, Parliament has endorsed the Secretary of State's considered opinion that a points-based system is the optimum mechanism for achieving management of it. That references to the need to lay the immigration rules before Parliament. That's what he was talking about there. So the court applied the up-to-date learning that interpretation of these sorts of instructions is a matter of law for the court. It's not simply that the court should accept the Secretary of State's own interpretation of his or her immigration policies. And the upshot was that the applicant in this case should have been invited to repair the deficit in his evidence. He was supposed to show 28 days of sufficient funds in his bank account, and he could only show 22 days, and he actually could have shown the full 28 days if the previous bank statement had been before the decision maker. That's essentially where the problem arose. So Lord Wilson was asking, well, how do we ground this in a head of challenge? Does this all arise from legitimate expectation, perhaps? Well, no, because in this case, the applicant was actually unaware of the policy. So that where was the clear and unambiguous representation that you would need to found a legitimate expectation case? It wasn't there. And so he decided, Lord Wilson, that the case of Nadaraja provided the answer. That was the decision of Lord Justice Laws. So where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, the law will require the promise or practice to be honoured unless there is good reason not to do so. That phrase comes up a lot, as we'll see. What is the principle behind this proposition? It is not far to seek. It is said to be grounded in fairness, and no doubt in general terms that is so. I would prefer to express it rather more broadly as a requirement of good administration by which public bodies ought to deal straightforwardly and consistently with the public. So the key phrase here is the sort of broad requirement of good administration, dealing straightforwardly in consistency with the public. And Lord Wilson referred to the very well-known case of Lumber, which held that the individual has a basic public law right to have his or her case considered under whatever policy the executive sees fit to adopt, provided that the adopted policy is a lawful exercise of the discretion conferred by the statute. It's a well-established principle of public law that a policy should not be so rigid as to amount to a fetter on the discretion of decision makers, and the decision maker must follow his published policy unless there are good reasons for not doing so. And again, we'll come back to that phrase in a later case. Lord Wilson said in his wonderful way, speaking for myself, I consider the Secretary of State's submission to be misplaced, even at the high level of pedantry on which it has been set. That was a reference to, in his view, the Secretary of State splitting hairs, because their submission was in order to have required the applicant to provide more evidence. There would need to have been the two pillars to start with, one bank statement from one date and then another one at a later date, rather than just the one that had been supplied. But unfortunately, the court didn't accept that submission and said that the decision maker should have noticed that there were statements in the series that were missing. So that was how it was decided on the facts. Next case is a good law project, or all the citizens in the High Court, and the matter went to the Court of Appeal. And this was about the duties owed in relation to public records, deriving from the Public Records Act 1958, which provides the duty to make arrangements for selecting which records ought to be permanently preserved. And the background to this was the use of private emails, WhatsApp chats for undertaking government business, although as it turned out, I think it was mostly for saying things like, you know, I'm going to be late for a meeting, rather than anything more substantive. Nonetheless, the challenge was that this practice was contrary to policy and quite a large number of guidance notes. And the issue was, did this duty in the Act to preserve records extend pre-selection? So before the decision's been taken as to which records should be preserved, is there any duty extending back before that? And the answer in both the High Court and the Court of Appeal was no, that the duty, Section 3 of the 1958 Act, didn't extend to that. Nonetheless, the declaration that was sought was that the guidance was enforceable and that public bodies were therefore required to comply with it without good reason not to. So that's the phrase that we picked up from the Mandalia case. The court recognised that policies will take a variety of forms. There'll be many different contexts. Some of them are sort of inward facing, as it was put, that don't concern the exercise of public powers. Also, there might be simply policies as to when to turn the heating on inside a building. And that's sort of at one end of the spectrum, very much sort of internally focused. These were policies that were directed to ministers and civil servants rather than the public. The court said that they could be better described in some cases as arrangements rather than guidance, noted the considerable discretion in the Public Records Act itself, and also that these policies weren't about individual cases or the rights of an individual. And indeed, a relevant factor is going to be, does a policy directly affect the public? Some form of dealing with the public is probably going to be necessary to engage the duty of compliance. And we take that from Mandalia and Nadaraja. So there's a reference, as we just saw in the quote from Mandalia and Nadaraja, the broad requirement of good administration to deal straightforwardly and consistently with the public. And of course, the general exhortation that guidance need not be slavishly followed. The court said it wasn't for the court to micromanage how the executive conducts its affairs in the selection and preservation of documents. There wasn't an enforceable duty in public law to comply with those policies. Also, they were formulated at different times. You couldn't read them as a coherent whole. Whether there should be a greater degree of consistency between them and whether that would be helpful was a matter for the executive to decide. And the court said that the Good Law Project's argument seeks to derive from internal policies absolute duties not to use certain methods of communication and to preserve communications which are not duties Parliament has imposed in the 1958 Act or elsewhere. And a couple of dicta which are worth noting. The court said, there is in our view a real risk that if policies such as the policies in issue in this appeal were regarded as legally enforceable, public authorities would be deterred from adopting them, notwithstanding the benefits that they can help to bring in terms of consistency, absence of arbitrariness, and equal treatment. As a reference to the case of A. In our view, the types of policy that are likely to attract a duty to comply are those that are the epitome of government policy. As in this case, as noted above, some of the policies were expressed to be guidance. Others might reasonably have been described as arrangements within the meaning of Section 3 of the Act, which is where the duty comes from. This strongly suggests that the 8 policies taken on their own or as a whole are not the sort of policies which are or should be subject to a duty to comply, enforceable by way of a claim for a judicial review. So it was really just too inward facing in this example to be legally enforceable. Finally, the case of AAA Syria and many others in the Rwanda policy case. So this is, of course, about the removal of asylum seekers to Rwanda, call that the Rwanda policy. And we had 8 conjoined cases representing judicial review of no less than 47 decisions, or almost as many counsel in court in the case, and concerned inadmissible claims, essentially where asylum had not been sought in the first safe country the individual arrived in, or if they had arrived by a dangerous journey, essentially the small boats, which we're all obviously aware of as an issue. Broadly, the case rested, the challenge rested very much on the Secretary of State's assessment of Rwanda as a safe third country. And for our point of view in this webinar, what we need to focus on is the need for the conclusion to be based on sufficient evidence and thorough assessment. That's what the court was looking for, and a need to lawfully conclude on the part of the Secretary of State that the arrangements made would not give rise to a real risk of refoulement, so the asylum seeker being sent back to the place where they feared persecution, a real risk of refoulement or ill treatment contrary to Article 3. There are many grounds of challenge, as we will see, but it was found that the subject matter of the Rwanda policy was suitable for inclusion in a policy statement, and it wasn't something that should have been placed before Parliament within the immigration rules. So it was very much that the court felt about prioritisation and process rather than making rules themselves. And then this is an interesting quote relevant to us from the Divisional Court. The government's proposal to relocate asylum seekers to Rwanda has been the subject of considerable public debate. It's therefore important to have the role of the court well in mind. In judicial review claims, the court resolves questions of law. Judicial review is the means of ensuring that public bodies act within the limits of their legal powers and in accordance with the legal principles governing the exercise of their decision-making functions. In addition, Parliament requires that public bodies act consistently with the rights and freedoms guaranteed by the ECHR, Section 6 of the Human Rights Act. The court is not responsible for making political, social, or economic choices. I refer back to my general points at the beginning. For example, to determine how best to respond to the challenges presented by asylum seekers seeking to cross the channel in small boats or by other means. Those decisions and those choices are ones that Parliament has entrusted to ministers. The approach of ministers is a matter of legitimate public interest in debate, and in this instance has stirred public controversy about whether the relocation of asylum seekers to a third country such as Rwanda is an appropriate response to the problems that the government has identified. But those matters are not for the court. The role of the court is only to ensure that the law is properly understood and observed, and that the rights guaranteed by Parliament are respected. So those were the parameters set by the court at the outset of the judgment. Now, there were many grounds of challenge. I don't have time to read them all out, but there they are. Not all of them are policy related as such, but some certainly are. The overall decision in the High Court was that the claims weren't unlawful for any of the generic grounds of challenge or by reason of the general claims of procedural unfairness, but because of the way in which the decision was gone about in terms of the implementation of the policy, some of the individual cases were flawed and were quashed and remitted for redetermination. The matter's now, of course, gone to the Court of Appeal late last month, and the Court of Appeal simply said, well, it will take as long as it takes in terms of when we're going to see a judgment. So despite the, on the face of it, at the start of it, quite narrow parameters, we can see that it is possible to push the envelope and to bring challenges in relation to a duty to follow policy. I'll stop there because I don't want to go over time, and thank you very much. Happy to answer any questions.
Brilliant, Kate. Thank you very much indeed. And for anyone interested in the arguments in the Court of Appeal in the Rwanda case, the video of that hearing is available on YouTube to watch with some interesting advocacy as well as substantive points. Just a final reminder that if you've got any questions or comments, please use the Q&A function on the system to ask them. We'll move on now to our final speaker, who is Jonathan Welch. Jonathan was called in 2019 and is already ranked as one of the top planning barristers under the age of 35. I've had the pleasure of leading Jonathan in a couple of claimant judicial reviews, including one where he took the habitats regulations ground and argued that successfully. He's also acted as sole counsel in a number of judicial reviews and as junior in some high profile judicial reviews, including challenges to development consent orders, and indeed has considerable experience in protest injunctions and committals, as well as other areas of public law covering local government, prisons and equality. So Jonathan, over to you now, please.
Thank you very much, Richard. Good afternoon, everyone. I'm going to hopefully rapidly traverse some recent case law in this area. Firstly, picking up where Michael Rhimes left off on the BF Eritrea case, linked to the A case in the Supreme Court. Then I will look at some other interesting recent case law in the area of challenges to policy. And finally, a case about the consequences of unlawful policy for other decisions. The first case then is BF Eritrea. A versus the Secretary of State, which Michael discussed, set out the principles. It was heard alongside BF Eritrea, and it sets out the principles, really reaffirming the Gillick case as to when a policy itself can be challenged. The facts of this case then: the Immigration Act 1971 deals with the detention of asylum seekers, distinguishing between those who are unaccompanied children compared with those who are adults over the age of 18. Now, the Secretary of State had made policy guidance for immigration officials in cases of doubt as to the age of an asylum seeker presenting as a child. One of the criteria was that an asylum seeker would not be accepted as being under 18 if their physical appearance or demeanor very strongly suggests that they are significantly over 18 years of age, and there is no other credible evidence to the contrary. The respondent here was an Eritrean national who arrived in the UK in 2014 and claimed asylum. He claimed to be 16 years old and was assessed by immigration officers, applying the policy as being an adult, and therefore was detained as if he were an adult. Subsequently, however, Home Office age assessments decided that he was younger than 18. This respondent challenged the policy by judicial review before the upper tribunal on the basis that it was unlawful, insofar as it was based on the policy because physical appearance and demeanor are inherently unreliable. Thus, the policy gave rise to a real risk of unfairness and unlawfulness. And the challenge succeeded by the time it got to the Court of Appeal. However, the Supreme Court allowed the Secretary of State's appeal and reversed the decision of the Court of Appeal. The Court of Appeal had relied on the line of cases from Tabak and Refugee Legal Centre, which appeared to establish an ability to review policy decisions which had breached a duty to act fairly, the standard being where the policy created a real risk of substantive unfairness. The Supreme Court, however, rejected the submission that a policy will be unlawful where it permits or encourages unlawful conduct by not sufficiently removing the risk that officials exercising discretion under that policy might make a mistake. For example, here, where they assess the age of an asylum seeker who claims to be a child. The bottom line here is that there is no duty for a policy to eliminate all risk of unlawful application. The domain of the court, so said the Supreme Court, instead, is to compare two normative statements, that is, the law and the policy or guidance, and just to look at them objectively to see whether there is a contradiction. The incorrect approach, the Supreme Court said, was to compare the law and the factual prediction of how the policy might be applied. And the latter, of course, would draw the courts into making a predictive factual assessment, which judicial review is inherently unsuited to. The Supreme Court said that the remedy, where it is alleged a policy has had an unlawful application, is not to challenge the policy, but to challenge the decision made under it, and to ensure there are access to the courts to compel a lawful application of the policy to the facts of a given case. I turn next to the case of MA. These two cases are cases that follow BF and A and are examples of these principles being applied. In MA, the subject again was asylum age assessments. The Secretary of State had issued guidance relating to those assessments conducted in Kent. The guidance was accompanied by a pro forma report to complete, which included tick boxes that were said to suggest certain elements of the age assessment procedures designed to ensure fairness were optional. The High Court had declared the guidance, including the pro forma, to be unlawful, but the Court of Appeal disagreed and reversed that. It said that the pro forma was simply the place for recording the decision and was not itself guidance. That was provided elsewhere, and the guidance, although not a complete statement of the law, itself cross-referred to appropriate case law and drew officers' attention to the need to comply with their legal duties and ensure the assessments were fair. And the Court of Appeal held that the guidance did not need to include every element of an assessment that would be required in order to be lawful, and they were able to sever the pro forma as not being part of the guidance. So this case is a good example of the difficulty in challenging a policy unless it clearly misstates the law. Policy or guidance will only be struck down if it permits or encourages unlawful conduct. And permitting in this context means something akin to sanctioning or positively approving, not merely failing to prohibit. Here, the guidance was capable of being operated in a lawful way. The next case is Timson. In this case, guidance was given by the Secretary of State in relation to deductions made from benefits. The claimant had fallen into debt, and at various times deductions were made from her benefits in order to pay debts owing to utility companies. The decision to make deductions was made pursuant to Secretary of State guidance. Challenge was brought on the basis that the guidance had wrongly directed decision makers to ignore the issue of whether the benefit claimant consented to the deductions, failed to direct them that they had to seek representations and information from the benefit recipient before deciding whether to deduct, and assumed that making deductions would be necessarily in the interests of the family, as required by regulations, without taking into account any personal circumstances. There were other grounds as well. All the grounds failed except one. The court found that the common law required benefit recipients to be given the opportunity to make representations or provide information. Although the regulations did not expressly impose such a requirement, that was the implication, and a failure to provide that opportunity and express it through policy would be a breach of the Tameside principle and also the cases of Doody and Padfield. The judge recognised the high threshold in the case law, particularly the Supreme Court's comments in A, but found this was an egregious case. And the judge, I would note, took into account the fact of the large number of cases decided and how they'd been decided. So this has been, I believe, appealed to the Court of Appeal, and it will be interesting to see the approach that's taken, particularly to the judge's comments about the factual result of the decisions under the policy. The next case is Bailey, which Michael Rhimes was involved in, my colleague. This case concerns guidance which has been revoked, but which the court still declared unlawful. In 2022, rules were issued to the Secretary of State relating to the parole board. Those rules were declared to be, well, interim relief was first obtained against those rules, and those rules were declared to be unlawful in the later hearing. But the Secretary of State not only had made the rules, but also had issued guidance training officials in how to apply the rules. That guidance, issued in July, had been revoked as soon as the interim relief was obtained. And the question then arose as to whether that guidance, having been revoked, should be quashed or declared to be unlawful rather, or whether it was academic because it had been revoked. The court disagreed with the defendant's submission that it was academic because it had been revoked, and applied the principles that we've been discussing about when guidance or policy will be unlawful. In particular, the court took into account that the guidance resulted in non-compliance by officers with other legal duties and was bound to have had concrete effects in thousands of other cases. So there was therefore a public interest in a declaration of unlawfulness. And also that guidance, although revoked, would be important context for the subsequent guidance. So this is an interesting case for showing that courts might take an interest in revoked policy or guidance, which was clearly unlawful, where there is a clear public interest because of the consequences of that guidance for many decisions. The next case, glass eels, I'm going to skip across very quickly in the interest of time. This is an application of the West Berkshire case principles, that an expression of policy in unqualified terms does not necessarily mean that there can be no exceptions to it. In this case, the Secretary of State had refused to permit the claimant to export glass eels. The Secretary of State elsewhere had made very firm commitments and statements about the approach they would take to such things, and they were challenged on the basis that they had vetted their discretion through that policy, but the court disagreed. And this makes an interesting reading for the application of those principles. The final case I'm going to discuss is TN Vietnam, which is on a slightly different topic. This is about the consequences of an unlawful policy or guidance and decisions taken pursuant to that. This case, in fact, relates to procedural rules, but the same principles would apply to policy. In this case, a decision to refuse an asylum claim was taken using a fast-track regime. The Court of Appeal, in separate proceedings, had held this system to be unlawful and systematically unfair. The question, therefore, was whether decisions taken under that fast-track regime were automatically a nullity. The Supreme Court in this case said, in this instance, no, it did not follow, because it was necessary in each case to demonstrate a causal link between the risk of unfairness created by a regime that's unlawfully unfair and what happened in the particular case. And Lady Arden, in the judgment in this case, said it was not necessarily the case that because the system was unfair, each decision under it would automatically be unfair. One would need to investigate the instant case and determine whether it was so tainted. This is a case about procedure and its lawfulness, but the same principles apply to situations where a policy or guidance is declared unlawful, and one then turns to consider individual decisions taken under that policy or guidance. And this is a good example of what is meant when academic lawyers talk about the doctrine of nullity being relative rather than being an absolute concept. And that brings me to the end of my part of today's webinar. Thank you very much.
Brilliant. Thank you very much indeed, Jonathan. Now we've got a little bit of time for questions, and thank you to those people who've posed questions online. I'm going to put the first question to Michael. I think the question is, in circumstances where there's a judicial review challenge to a particular decision, including, for example, on the basis that it was irrational, but it is linked to government policy and therefore, as it were, a decision by the court that a decision was irrational would have implications for the policy. The question is how, as it were, the law on the legality of policy might feed into a judicial review against a particular decision in those circumstances.
Thank you very much. So as I was discussing, the Supreme Court in A recognized that there's a difference between, challenges to policy, where it's the Gillick test that will apply. And even though a policy is lawful, it may result in a decision that on the facts was unlawful. So it's entirely possible to have a challenge to a decision that leaves the policy unchallenged. And so in order to challenge the policy, you would really need to show that the Gillick test has been breached. It should be said that as I gave the example of Gardner as a situation where a policy was found to be irrational, but overall it would be difficult to argue that a policy was irrational totally. One recent example was Howard, where there was a good character policy for all individuals seeking naturalization as British citizens. And that was held by the High Court to be irrational. in circumstances where the government had made firm commitments to treat the Windrush generation differently. That was overturned by the Court of Appeal. And so that, again, sort of illustrates the difficulty of showing in the abstract that a policy is likely to be unlawful. But absolutely, as I've said, a policy can be lawful, but still result in a particular decision which was unlawful.
Okay, thank you. And then, Kate, we've got a question which I'm going to put to you, which is about government guidance on COVID restrictions and where that would or potentially would have been incorrectly stating the law, whether that would have been unlawful.
But potentially, yes. I'd have to go back to the guidance to offer a proper view about it. But yes, I mean, if the guidance was intended to be a full statement of the law and that was wrong, then yes, that potentially would found a challenge. Although it's possible that it would come down to the interpretation of what the guidance was actually wanting to achieve. Was it just making recommendations, or was it making a full statement of the law?
Excellent, thank you. And then a question, Jonathan, I'm going to ask you to take, if you don't mind, which is where now quite often statute confers an express power on ministers to issue guidance to public bodies, but historically there wouldn't normally have been such a statutory provision, and any guidance or policies would have been issued under other inherent, as it were, powers. The question arises then is, do you think it makes any difference in terms of the duty to follow policy, such as it is, if the policy is issued pursuant to an express statutory power, rather than just something which is produced as a matter of course in a public body's functions?
Thank you. I think it's Hugh Craddock who's asked the question. I think the short answer is no. This is a sorry, the question has just disappeared from my screen. The answer is no, it doesn't make a difference. Likewise, to the question of whether policy has to be in accordance with the law, whether there's a statutory requirement or power to create policy or not, the test will be applied from the A and Gillick cases as to whether that policy is lawful. Likewise, the duty of fidelity to guidance or policy, whether statutory or non-statutory, will not make a fundamental difference to that question. I don't know if Kate had anything to say about that, given that it sort of strays slightly into the topic you were discussing.
No, well, no, I agree with you, Jonathan. I don't think the origin makes any difference. It'll be questions such as whether it's how inward facing or how public facing it is. Does it impact on individual rights? Those sorts of concerns.
Michael, anything you want to add?
Just to add one observation on that. The Supreme Court in A does discuss a very specific kind of case, which is where the Secretary of State gives guidance to his or her civil servants about how to exercise their discretion. And it may be that in that kind of case, the court would be more likely to conclude that the policy was intended to be a full statement of the law, because it wouldn't be reasonable to expect civil servants working under a particular Secretary of State to obtain independent legal advice. And so in those circumstances, it may well be that if the policy misstates the law or omits something, that would more readily invite the court to conclude that the policy was unlawful. But again, that's just an illustration of the particular factors of the Gillick test.
Good. Okay, so we've got a couple of minutes left, and what I'm keen to do is ask each of you just to kind of sum up where you think we stand for the future, given the litigation there's been in the last couple of years, both in relation to challenges to policy and guidance, but also arguments about the duty to follow policy outside legitimate expectation, for example. Is this going to lead to more or less litigation in the future, do you think? Kate, can I start with you?
I don't think in terms of my particular area there's been anything seismic, but in terms of the Rwanda case, I'm reminded of a discussion that we had with our colleague Flora Curtis, and she wondered whether, even though the policy itself has so far been found to be lawful, because of the flaws in the implementation of the individual decisions, whether effectively the policy will be done down sort of, by death by 1,000 cuts. I thought that was an interesting point that she made.
Good, thank you. Jonathan?
Yeah, I'd sort of echo that. I mean, I think just in my anecdotal experience, that challenges to the application of, or the correct interpretation of a policy in its application by a decision maker are more numerous than challenges to the policy itself in terms of the quantity of litigation. That's particularly the case
We can't, you've gone a bit quiet, I'm afraid, Jonathan.
No, I pretty much finished what I was going to say. Thanks, Richard.
Okay, thank you. Michael?
So I think definitely challenges to policy have become more difficult, essentially, as long as the decision maker can show that the policy didn't require it to breach the law, then it's unlikely that the policy will be unlawful, which I think is helpful. And hopefully that will encourage more public bodies to adopt policies without the fear of, having to necessarily publish a textbook on the topic. But that does mean that it will have to be shown that an individual decision was lawful. And so the fact you can't challenge the underlying policy necessarily doesn't mean that you can't challenge the underlying decision.
Excellent, thank you. Well, thank you to all three of our speakers, and indeed to all of those who've attended. Our next public law webinar is going to be on the 20th of June. And that's an update on judicial review practice and procedure, covering standing witness statements, disputes of fact and expert evidence. So hopefully we'll see many of you back for that. Thank you very much indeed.